Are you a tenant with a case in landlord-tenant court? My name is Jordan, and I'm an attorney on the housing team at Neighborhood Legal Services program, where I help my clients whose landlords have sued to evict them. In today's video, I'm going to give you some information on legal defenses. This information is meant to help tenants who are representing themselves in court without a lawyer, which is called being a pro se tenant. If you would like to see if you qualify for free legal assistance, call the Landlord-Tenant Legal Assistance Network, LTLAN, at 202-780-2575. The information in this video is not legal advice, and it is specific to courts in Washington, D.C. because the laws vary across the country. Today we'll talk about what common legal defenses are and are not, as well as common legal defenses in non-payment of rent cases and lease violation cases, as well as two defenses that apply in all kinds of cases. Let's get started. So when you're in court or when you're speaking to a judge, you might hear the term legal defenses come up. So what is a legal defense? Well, in landlord-tenant court, every case starts with a landlord suing a tenant to evict them. Legal defenses are your challenges to your landlord's claims against you. Strong legal defenses can help you in multiple ways, including reducing the amount of rent that you owe, countering your landlord's claims, and in some cases, even preventing an eviction altogether. As a note, the term legal defenses does not just refer to any argument in court. Rather, legal defenses are a small number of examples that are written into the law. This means that not all reasons or explanations as to why you fell behind in rent are legal defenses. You may have an argument that is logical and compelling, but if it is not written into the law, it is unfortunately not a legal defense. So let's say, for example, you owe $1,000 because you fell behind in rent when you lost your job. Unfortunately, not being able to pay that rent because you lost your job is not a legal defense. But let's talk about some things that are legal defenses. First, we'll start with legal defenses in a non-payment of rent case. A non-payment of rent case is when your landlord is suing you to claim that you owe rent. We're going to discuss 5 common defenses in depth, but there are many possible defenses. Luckily, there's a court form called an answer that lists most of the defenses in non-payment of rent cases. The form looks like this, and it is linked in the caption below. You should read through the checkboxes and consider if any of the defenses apply to you. The first page of the form instructs you about how to fill it out, and the checkboxes begin on page 4. Now, the court does not require you to fill out this form unless you want to have a jury trial, or if you're asserting specific defenses that are named on page 1 of the form. But even if you aren't filing the form, it's helpful to look it over just so you can understand what potential defenses you might have in your case. The checkboxes will describe possible defenses like, my landlord is charging me more than I should, or I believe my subsidy provider stopped paying the landlord through no fault of my own. Today, we'll go through 5 common defenses for non-payment of rent cases. Those defenses are, number 1, disagreeing with the amount of rent your landlord claims you owe. Number 2, owing less than $600. Number 3, paying back all the rent you owe, called redeeming. Number 4, housing code violations that your landlord refuses to fix. Or number 5, illegal rent increases. First, disagreeing with the amount of rent that your landlord claims you owe. Let's say, for example, you always pay your rent of $1,000 per month. And even though you paid your rent in full and on time last month, you're surprised to learn that your landlord filed a non-payment of rent case against you, saying you owe $1,000 for last month. In this case, you disagree with your landlord's claim that you owe $1,000. That disagreement about the rent that you owe alone is a legal defense. In fact, any disagreement about the amount of rent that you owe is a legal defense. This is still true even if you owe some amount of money, but it's less than the amount your landlord is claiming. So if you owe $1,000 in rent and you only miss 1 month's payment, but your landlord says that you missed 2 months, telling the court the correct amount is a legal defense. Number 2, owing less than $600. The law does not allow a landlord to evict a tenant who owes less than $600 at the time the case is filed. If your landlord claims you owe an amount over $600, and you know that that is not true, even if you do owe some rent, as long as it is less than $600, that is a legal defense. Number 3, paying back all the rent you owe. It's called redeeming. If you pay back all the rent you owe at any point in your case, that is a legal defense. Number 4, housing code violations that your landlord refuses to fix. Your landlord is required to keep your unit in a habitable condition. If there are issues with your unit that you have told your landlord about and that they have not fixed, like the heat not working, a broken window, or a rodent infestation, the law says that you may owe less money in rent than your landlord claims. That's a legal defense. Number 5, illegal rent increases. Your landlord cannot raise your rent during the terms of your lease. If you are not currently under a lease, or you are signing a new lease, your landlord must notify you in writing at least 60 days before your rent increases. If your landlord did not notify you in that time, that is a legal defense. You may also disagree with the amount of rent you're being charged if your rent is subsidized or if you live in rent-stabilized housing. If you fall into one of these categories and you want to see if you qualify for free legal assistance, call LTLAN. In a lease violation case, your landlord is claiming that you broke the terms of your lease in some way. In response to that claim, we'll discuss the 2 most common legal defenses. Just like in non-payment cases, there's a checkbox answer form linked in our caption below that names most potential defenses. The form looks like this. Again, you're not required to file this form, but it can be a good idea to look through the form in case there are defenses that apply to you. Now we will focus on the 2 most common legal defenses in a lease violation case. Number 1, disputing the claims of your landlord. Number 2, fixing the violation, also known as curing. So let's start with number 1, disputing the claims of your landlord. If you disagree that you violated your lease, that could be a legal defense. So say, for example, you have a dog, which you're allowed to have under the terms of your lease, but your landlord sues to evict you, saying that you have an unauthorized dog. Your legal defense would be that you disagree with the claim that you have an unauthorized dog in your apartment because your lease permits you to have a dog. In other examples, if your landlord claims that you broke your lease by having an unauthorized occupant in your unit and the person they're referring to doesn't live with you, that's a potential legal defense. Maybe your landlord has claimed that you've caused disruptions to other tenants or employees and you don't believe that to be true. That's also a potential legal defense. Moving on to number 2, fixing the violation or curing. In a lease violation case, your landlord must give you 30 days to fix the lease violation, like removing an unauthorized dog, cleaning your unit, or changing your behavior towards building employees, before they file a case against you. If you stop the lease violation within 30 days of receiving that notice, your landlord is not allowed to file a case. If you fixed the issue but your landlord still files a case, that is a legal defense. For any kind of case, remember these 2 legal defenses too. Number 1, retaliation. Your landlord is not allowed to evict you only because you made a complaint about housing conditions or asserted your rights as a tenant. If you believe your landlord is evicting you only because you asked them to fix an issue in your apartment, reported a concern to the Department of Buildings, or joined a tenant organization, this could be a legal defense. Number 2 is improper notice and service. Now, this issue is a little bit technical, but it's important to know, so stick with me. Your landlord is required to follow very specific regulations when they give you notice of past due rent and when they tell you about the complaint that initiates an eviction case. If they do not follow the rules, this could be a legal defense. Let's talk first about notice. Notice is a warning from your landlord that you owe rent or you violated your lease, and that your landlord is planning to file a case against you in court if you don't fix the issue. As we've done so far, we'll describe some potential issues with notice, but even more can be found in both the non-payment and lease violation checkbox answer forms shown here on the screen and linked in our caption. To go over some specifics, your landlord is required to give you that notice of past due rent or lease violations before they take you to court. The notice must be posted on your door and then mailed to you, or directly handed to you or handed to someone else in your home who is not a child. The notice must be written in English and in Spanish, as well as any other primary language that you speak that your landlord knows you speak. If you live in subsidized housing, your landlord is required to include a notice of your rights under the Violence Against Women Act, or VAWA, when they provide notice before filing a claim. Once your landlord sues you, they are required to serve you with a copy of the complaint and the summons that they filed with court. The complaint must be posted on your door and then mailed to you, or directly handed to you, or handed to someone who lives in your home who is over the age of 16. If you think this legal defense might apply to you, call LTLAN. The number is in the caption below. This is not a complete list of legal defenses. There are many more. It's just an overview of some of the most common ones. Even more of the legal defenses can be found on the checkbox answers linked in the caption. Remember, if you have legal defenses, it is important to tell the court once you realize you have them. Be sure to raise your legal defenses as soon as possible, ideally at your initial or further initial hearing, because it will allow you to fight your eviction in court. Good luck, and thanks for watching.